Next case we'll hear is Lee and Lebrow versus Sailors.
Good morning, gentlemen. May it please the court. My name is Michael Mead, and I've asked the clerk to reserve 5 minutes for rebuttal for me. Unlike the other cases that have appeared before you this morning, this case has not gotten to trial yet before it was terminated, and in my humble legal opinion, was terminated prematurely. It's a basic lawsuit for the breach of a real estate sales contract, which was kind of stopped in its track.
Well, help me here. There were two pieces of litigation. Was there any difference in the second litigation from the first other than the remedy sought? I mean, wasn't it based on the same facts and relationship between the parties?
That is a true statement.
Then are you allowed to split causes of action, say, okay, I'm going to go for specific performance here, damages here, and injunction here? Can you file 3 separate lawsuits? You lose one, move on to the next, lose another, move on to the next. Are you allowed to do that?
In general, no, sir.
Can it help me as to why this is any different than that?
I believe the unique and specific and direct answer to your question is the particular law of this case was predetermined and set and was a final ruling by that first action I refer to as the 153 case, the first case. In that particular case, the ruling and the final judgment concluded that it did not terminate or vitiate, as the court used, any of the other remedies. And that's what makes it unique to this particular second suit in a direct response to your question.
Would a trial court even have the right to do that?
Yes, sir, they sure did, and did it. And that
Can a trial court create a cause of action where there isn't one?
No, sir, there was one. But the trial courts in the first case confirmed and created as a rule of law, unappealed, that those other remedies would still be available.
Okay,
and that's what, I'm sorry.
Go on.
And that's what makes it unique, and that's what makes our situation here unique, is the other principles that you were starting to ask me about, I believe, are different and unique. I'm not suggesting those principles of law don't exist. I'm suggesting to the court that the ruling in the other case specifically kept alive this remedy that's now being sought, which was stopped in its tracks before we ever got to a trial on the breach of contract.
Okay, the trial court here references the arbitrator's award, and specifically I'm referencing paragraph 18 of the arbitrator's award. It's referenced by the trial court. Respondent Sailors did not establish that claimant Lee misrepresented or suppressed any material facts about the Highway 331 property. Isn't that what your lawsuit is based on, your second lawsuit? That there were misrepresentations regarding the Highway 331 property?
No, sir. My particular lawsuit is for the forfeiture of the earnest money deposit because the purchaser did not go through with the contract, because he breached the contract.
Okay.
And that's the principle upon which the appellee, and I believe the court in the cases before your honors today, has simply made a misapplication of a well-established and a well-recognized principle of law, and that having to do with res judicata and estoppel by judgment. In this particular case, in my belief, they want to, but for the previous judgment, but for that, this case would be going on and would probably be nearing the actual trial of the case. But it got stopped in its footsteps, in its normal path towards a trial, by virtue of going back and reaching this other judgment. But I use the term, I think, in my brief, they cherry-picked out of that final previous or other case, and use that part of it to simply say, because of common parties, this case should be stopped. But they didn't bring along or look to the entire matter which was contained within that.
Well, counsel, when the arbiter says, I didn't consider anything other than the specific performance issue, how did that eliminate the necessity for you to have asserted all of your claims that were available to you at that time initially? Just because he didn't address those. In other words, if you have a claim for damages versus a specific performance. Now, if you had pled those in the alternative in court, you may have been forced to elect a remedy down the road. But are you not required to bring all the claims available at one time?
Under the normal rules of engagement, I would agree with Your Honor. But what we have here, if I may explain, is in what takes that normal thinking and takes it out of that particular box is that the arbitrator in this particular case was only had one remedy submitted to him, that was for specific performance. It didn't address the other ones. Now, had he gone on and ruled somehow that you've also lost all your other remedies because you elected your remedy or you didn't plead in the alternative, but this particular unique case, and that's why I believe it is unique, but it also embodies the principle of law that even if an arbitrator makes a mistake, and even if it is an error of law or an error of judgment, and assuming what you have just pointed out to me would have been an error on his part, he nevertheless said, and I believe very clearly, and then upon request for clarification in that first case, made it very clear that it was not the arbitrator's conclusion or decision or part of his ruling to terminate these other remedies.
Okay, but it wasn't the arbiter's duty to determine whether there were other remedies. We have a rule of law that you can't split your causes of action.
And that's what I'm not arguing with that, Your Honor. I think you're correct. But I believe the law of Florida, as enunciated by the Supreme Court, provides that even if that arbitrator made that error of law, and this is what's kind of hard for maybe us to grasp, but certainly I believe it's correct law, that even if that arbitrator made that mistake, failed to recognize splitting of cause of action or something of this nature, that once that became the final judgment of, I'll call it case number one, that once that happened, once it went on appeal, although I would argue to this tribunal, had that even been appealed, absent those very specific things which are contained within the arbitration code, that still would have been the law.
Okay, his statement, I've reached no conclusion that would vitiate this contract or impair other remedies if any are available. Well, it's not his decision that's vitiating the other remedies. It's the rule of law. So he's not creating anything here. He's just saying my decision doesn't impair any other remedies they may have. Isn't that a difference?
I believe, and yes, I think that is what he said, but he also went on, the arbitrator, because the trial, if I could just explain a little bit more to make sure that there was no misunderstanding what the arbitrator wanted to accomplish. When the defendant in that particular case, the defendant in that particular case, the first case, went back to the trial court after the entry of the final judgment and said, because I want that earnest money deposit, the appellee. The trial court then said, well, let's make sure what the arbitrator said. So the arbitrator was posed a letter to him. Is it clear that you did not intend to terminate any of these other remedies?
But that's what I'm saying. He didn't intend to, but he wasn't the one that precluded the other remedies. It was the law of Florida that precluded the other remedies.
But I think he enunciated, and that's what's so hard to grasp here, Your Honor, is he did enunciate what the law was, possibly erroneous. But that arbitrator's decision was to, and he went on to say in his confirmation, because the trial court indicated.
I have his confirmation right in front of me, and he says, the parties' agreement contains a discrete remedial provision for dispute over escrowed funds. In the award of March 21st, 2006, I did not decide any claim that could be brought under that provision. I mean, that's clear. He couldn't. and did not intend to foreclose any remedy available under that provision. It wasn't his intent to foreclose the remedy. But I'm saying he didn't foreclose the remedy. Wasn't it the law of Florida that foreclosed the remedy?
I see my time's up, and I'll do my best to answer your question. I believe he created a law. He created a principle within that case in which he enunciated once, and then again when he said, in the award of March 21, 2006, I did not decide any claim that could be brought under that provision and did not intend to foreclose any remedy available under that provision. If you look at the totality of the arbitrator's ruling, which is part of the record, and you look at his original ruling, the clarification requested by court number 1, and the fact that that did become the law of the case, that ruling, although may be technically flawed, legally flawed, or even factually flawed under the law of Florida, that is the rule. And with that decision, that cannot be used as a bar, therefore, to our subsequent breach for a different remedy. Thank you.
May it please the Court. My name is Daniel Hartman. I'm here with my law partner, Gene Curtin. We represent the appellee, Russell Sailors, in this matter. In this case, the parties are in agreement as to the legal principles as well as their interpretation. We simply disagree as to the outcome warranted by application of those principles to the facts. The appellant has taken two positions. The first, that the arbitration award and clarification left undecided both his current claim for breach of contract seeking money damages and alternatively left undecided the dispute over the release of the earnest money or his ability to pursue the earnest money. And these are two distinct matters decided in the court's order below. The order under review bars the second claim for default under the contract based on res judicata and properly resolves the only matter left open by the award, which was the escrow claim dispute. In his award, the arbitrator did not leave a broad spectrum of remedies and claims open for subsequent litigation, as would be contrary to the doctrines of res judicata. The clarification clearly sets forth what was and was not decided by the award, and thereby clarifies the general language relied upon by the appellant in paragraph 20 of the findings and reasons attached to the award. The clarification states that he did not decide, or that the award did not decide, any claims that could be brought or remedies available under paragraph 14A of the real estate contract. Paragraph 14A is narrow and provides essentially only a mechanism by which an escrow agent may submit a dispute involving conflicting claims on an earnest money deposit for resolution. This issue of entitlement to the deposit was the only potential claim that was preserved because at the time of arbitration, there was no such claims. The claims, this issue of 14A, there was no dispute over the escrow monies at the time of arbitration. Therefore, the arbitrator could not have ruled upon it. Paragraph 14A does not authorize the relitigation of any action involving default under the contract. A claim for default under the contract was brought at arbitration, and the remedy of money damages was available to the appellant at arbitration in the companion case. And it's now foreclosed by the arbitration award and final judgment under a proper application of the doctrine of res judicata. The arbitrator wisely anticipated that such a dispute over the deposit might arise following the award. The appellant's attorney is the escrow agent in this case and has, since the award was issued, had conflicting demands made on him for release of the deposit. Paragraph 14A allows the escrow agent to submit the claim to his choice of an arbitrator, a court, or the Florida Real Estate Commission. In this case, the escrow agent, appellant's attorney, submitted it to the court. And as envisioned under 14A and consistent with Florida law, the court considered the award and final judgment and determined entitlement to the deposit. He found that it would be inherently inconsistent with the final judgment and award to grant the appellant money damages. The award and final judgment state that the appellant shall have and take nothing from the appellee. And just in summary, the order properly found that the four identities existed for res judicata to act as a bar to this instant or second action by appellant alleging default under the same contract between the same parties. And the order, in paragraph 14 of the order, properly resolves the only matter left open by the arbitration award, because it didn't exist at the time of the arbitration, the dispute created by conflicting claims made on the escrow agent for the earnest money. And consequently, we'd ask that you affirm the order under review. Thank you. Any questions?
Thank you very much, counsel.
Gentlemen, going back, excuse me, to the questions that the first trial court posed regarding the arbitration entry by the arbitrator. This was back when Mr. Saylors was the appellee was seeking in the first case to have the earnest money deposit sent to him. One of the questions, Respondent Russell Saylors understood your award not only to deny the specific performance, but also to require payment of all earnest money deposits to Saylors as well. Obviously, this would vitiate the contract, any other remedies that may be available under the contract, as well as the pending circuit court action. After extensive hearing on the matter, the circuit judge was unable to decide conclusively if it was your intent to award the Respondent Saylors the $20,000 in deposit money. We therefore respectfully request that you answer the following questions, and that had to do with that. And in response, the arbitrator, and this is 125 of the record, in the award of March 21, 2006, I did not decide any claim that could be brought under that provision and did not intend to foreclose any remedy available under that provision. Even if that was erroneous, under the case of Schumacher Holdings versus Noriega, even if that is erroneous, that is still the law of that case, and therefore there is no legal impairment to this second case going forward seeking clarification.
Counsel, before let me see if I can clarify something. When you went to arbitration, because that was provided for in the contract, you didn't take the escrow agent as a party before the arbitrator, did you?
That is true.
So the arbitration dealt with the claims existing between the putative buyer and seller of the property, at which time you had two options. There was either specific performance or damages under the contract. That would not be right?
No, sir. The only remedy that was sought before the arbitrator.
Not what was sought, but what was available under the contract. You get specific performance of the contract, or failing that, damages under the contract.
That is true, but
you could have sought either.
That's true, yes, sir.
Well, if you could have sought either, were you not required to bring them at that time, or be barred from bringing them once the decision on the only issue you sought to have brought?
I cannot argue with that principle of law and accept that as how I've always understood it. But to further my argument, here, once the arbitrator, assuming that to be erroneous, and I think all the four of us agree that would be erroneous, that you couldn't elect remedies or you were barred. But in this particular case, the erroneous ruling of the arbitrator is the law of the case. When that final judgment goes unappealed, even though it may be erroneous as to fact and as to law, in the absence of one of those 6 or 7 categories of fraud or something of that nature, and that's where the Supreme Court gets into this conversation, these rulings that say arbitration shouldn't merely be one of the steps in the route to the final resolution, that once the parties have agreed to arbitration, be it legally in error or legally incorrect, it then becomes the law of the case. And they want to have it both ways. They want to be able to say, well, the arbitrator's award precludes us from determining now who's going to get the earnest money deposit, but don't look at the whole arbitrator's award, because if you do, that arbitrator's award is going to tell you, yeah, go decide. And I see my time's up, but I'd be happy to try to answer any.
Thanks very much.
Thank you, gentlemen. It's been a pleasure and honor to be here.